How's it going, everybody? Welcome back to Lead Therapy. I hope everybody is doing well. And I really appreciate you taking your time tuning into the video. I just want to take a little bit of time to thank everybody for the past couple of months that have subscribed to the channel. There were about 400 new subscribers last month, and so far this month, there's around 300 new subscribers. Welcome aboard. Thank you very much. I also want to thank everybody that's been liking, sharing, and subscribing and hitting those post notifications. You guys have been crushing it. I really appreciate that as well. An Oregon sheriff is part of a group that is suing to block new gun laws. For the people of Oregon, they could be less than 3 weeks away of a complete and total shutdown of lawful commerce in arms in Oregon, with ballot measure 114 and its new magazine ban and permit to purchase requirement slated to take effect on December 8th, according to the Oregon State Sheriff's Association. Once the law is enacted, Oregon residents will need to obtain that purchase permit before they can legally acquire a firearm. But the state has not yet developed the permit itself, and it is unlikely to do so before December 8th. Then, of course, there's the issue of Measure 114's constitutionality. Can a law requiring would-be gun owners to obtain pre-approval from the state, along with going through a mandated training course and banning the sale, manufacture, and possession, in most cases of commonly owned firearm magazines, really stand up to court scrutiny? The Oregon Firearms Federation, an Oregon gun store owner, and Sherman County Sheriff Brad Lohrey are among the critics of Measure 114, and now they're suing to prevent the new gun control laws from taking effect. The plaintiffs seek a court-ordered injunction that would bar the measure from becoming law, and a court ruling that Measure 114 is unconstitutional. If a judge isn't inclined to prevent the entire measure from taking effect, the plaintiffs ask the court, in the alternative, to at least bar the restriction on gun magazine capacity. The lawsuit names Oregon Governor Kate Brown and Attorney General Ellen Rosenblum, whose offices have said it will defend against challenges to the measure set to go in effect December 8th. The vast majority of the new lawsuit is dedicated to challenging the new ban on magazines, though the lawsuit does ask for the entirety of Measure 114 to be enjoined from enforcement. As the plaintiffs allege, Oregon's new ban on large capacity magazines strikes at the heart of the Second Amendment's protections, while the ban's prohibition on the continued use of large capacity magazines in most settings, including self-defense, violates the Constitution's takings clause. Millions of law-abiding Americans own firearms equipped with magazines that are capable of holding more than 10 rounds of ammunition. There is nothing unusual or novel about this technology. Many of the nation's best-selling handguns and rifles come standard with magazines that can hold more than 10 rounds, and firearms equipped with such magazines are safely possessed by law-abiding citizens in the vast majority of states. The reason for the popularity of these magazines is that in a confrontation with a violent attacker, having enough ammunition can be the difference between life and death. Although magazines capable of holding more than 10 rounds have existed and been in common use for more than a century, Oregon, through 2022 ballot measure 114, bans their manufacture, sale, import, or transfer effective December 8th, 2022. In Oregon's view, these standard issue magazines are actually large capacity magazines that threaten public safety. In November 2022, the state took an additional and extreme step, banning mere possession of magazines more than 10 rounds. Under 114, owners of such magazines who want to keep the property they lawfully acquired and have used for only lawful purposes may no longer continue to do so. 114 violates multiple constitutional provisions. First, it permissibly burdens plaintiffs' Second Amendment rights. The Second Amendment protects the right to keep and bear arms, typically possessed by law-abiding citizens, for lawful purposes. This applies to keeping and bearing arms, both inside and outside the home. The standard for applying the Second Amendment is as follows. When the Second Amendment's plain text covers an individual's conduct, the Constitution presumptively protects that conduct. The government then must justify its regulation by demonstrating it is consistent with the nation's historical tradition of firearm regulation. Only then may a court conclude that the individual's conduct falls outside the Second Amendment's unqualified command Capacity limitations just aren't a part of the historical tradition in the country. You don't find a host of statutes from the mid-1800s banning the use of multi-shot revolvers, for instance, nor do you find any evidence of moms demanding lever actions be banned after the Civil War, even when gun companies were bragging about magazine capacity that was so large that you could load on Sunday and shoot all week long. It's not until you get into the 1980s that you start to see bans on large capacity magazines, an invented term that has no real definition other than what's provided by lawmakers. In California and Oregon, for example, large capacity is defined by anything that can hold more than 10 rounds, while in Colorado, a large capacity magazine can hold no more than 15 rounds. Local officials in Columbus, Ohio, recently announced plans to put a municipal magazine ban on the books. In that case, a large capacity magazine would be defined by any magazine that can accept more than 30 rounds. The real definition of a large capacity magazine is a magazine anti-gun activists want to ban. And as the new lawsuit makes clear, these activists don't have a legal leg to stand on. Under the text, history, and tradition test laid out by the Supreme Court in Bruin, whether that's enough to endanger the entirety of Measure 114 remains to be seen. But I also believe this isn't the last lawsuit we'll see filed before December 8th. The future litigation may focus more on the permit to purchase requirements that will impose severe burdens on all those attempting to exercise their Second Amendment rights. I would like to hear what you guys think in the comment section down below. Do you think they'll be able to win with this lawsuit, even though this was voted in by the people and not anti-gun politicians? And if you guys can do me a favor by liking, sharing, and subscribing and hitting those post notifications, and I hope to see you guys in the next video.